The structure of the Texas Judicial Branch is laid out in Article 5 of the Texas Constitution and is further defined by statute, in particular the Texas Government Code and the Texas Probate Code. The structure is exceedingly complex, featuring many layers of courts, numerous instances of overlapping jurisdiction, both in terms of amount and controversy on questions of specific territorial authority, a myriad of differences between counties, and an unusual bifurcated appellate system at the top level found in only one other state, Oklahoma. The municipal and justice of the peace courts are the most active courts, with the county level and district courts handling most other cases and often sharing the same courthouse. Administration is the responsibility of the Texas Supreme Court, which is aided by the Texas Office of Court Administration, the Texas Judicial Council, and the State Bar of Texas, which it oversees. The State Bar of Texas is a mandatory bar rather than merely an association of lawyers such as the ABA or local bar associations. This means it plays a formal role in Texas government rather than just as an advocate or special interest for the legal profession. In order to practice law in Texas courts, an attorney must be licensed and must pay dues. The public can obtain basic information on all Texas attorneys, including their bar number, license status, and disciplinary record, from the bar's website at texasbar.com. In the 19th century, Texas had a reputation for arbitrary frontier justice, as exemplified by the Justice of the Peace Court of Judge Roy Bean, who fancied himself as the law west of the Pecos. The poor quality of the state's judicial system in Texas at the early period has been attributed to its then shortage of proper law schools and law libraries, as well as the traditional preference of Texans for self-help justice. Texas is the only state besides Oklahoma to have a bifurcated appellate system at the highest level. This means Texas has not one but two high courts. The Texas Supreme Court hears appeals involving civil matters, and the Texas Court of Criminal Appeals hears appeals involving criminal matters. One notable exception is in the case of juvenile justice cases, which are considered civil in nature and heard by the Texas Supreme Court rather than the Court of Criminal Appeals. Unlike its counterpart in Oklahoma, the Texas Supreme Court is not really supreme when it comes to a jurisdictional game of ping pong or tug of war between the two high courts, because both are co-equal. Article 5, Section 1 of the Texas Constitution states, "The judicial power of this state shall be vested in one Supreme Court, in one Court of Criminal Appeals, in courts of appeals, in district courts and county courts, in commissioners' courts, in courts of justices of the peace, and in such other courts as may be provided by law. The legislature may establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof, and may conform the jurisdiction of the district and other inferior courts thereto." As such, the Texas legislature has created additional courts to address caseload pressures driven by population growth in different areas of the state. Further sections of Article 5 spell out the basic requirements for each court's jurisdiction and for its officers. The Texas Supreme Court hears appeals involving civil matters and does not hear any appeals involving criminal matters except when the defendant is a juvenile. Under Texas law, juvenile proceedings, even those involving criminal activity, are considered civil matters under the Texas Family Code. Thus, the Texas Supreme Court hears such appeals, but it defers to the Texas Court of Criminal Appeals in matters where the Texas Penal Code must be interpreted. The Supreme Court also maintains responsibility for attorney licensing and discipline. The Texas Court of Criminal Appeals hears appeals on criminal cases, excluding those involving juvenile proceedings. Cases in which the death penalty was imposed are directly and automatically appealed to this court, bypassing the intermediate courts of appeals which hear both civil and criminal cases. Texas has 14 courts of appeals which have intermediate appellate jurisdiction in both civil and criminal cases. Death penalty cases, however, are automatically appealed to the Texas Court of Criminal Appeals and thus skip the intermediate tier in the appellate court hierarchy. The total number of intermediate appellate seats is 80, with membership ranging from 3 to 13 justices per court as set by statute. All cases are heard by a 3-justice panel unless a hearing en banc, meaning all justices at once, is ordered, except where a particular court has only 3 justices assigned to it, in which instance all cases are automatically heard en banc. An example is the 12th Court of Appeals. The en banc process is used to maintain consistency in the court's jurisprudence, to overrule existing precedent that is binding on individual panels, and to set new precedent on an unsettled question of substantive law or procedure. The Texas legislature determines which counties are included within a particular Court of Appeals' district, and has shifted counties between courts to balance the docket. The Texas Supreme Court seeks to even out imbalances in appellate caseloads on an ongoing basis with docket equalization orders that provide for transfers of batches of cases from the busiest appellate courts to others with spare capacity. In an oddity, 2 of the 14 courts, the 1st and 14th, both sitting at the repurposed historic 1910 Harris County Courthouse in Houston, have concurrent jurisdiction over the same 10 counties, the largest being Harris County. Parties who want to appeal a case from a court in any of these counties are required to state in their notice of appeal that they wish to appeal to either the 1st or the 14th Court of Appeals, and then must wait and see to which one of the 2 they are assigned randomly. An even more bizarre situation occurs in East and North Texas, where the 6th Court has 4 counties, Gregg, Rusk, Upshur, and Wood, which overlap with the 12th Court, and also has Hunt County overlapping with the 5th Court. The Texas District Courts are the trial courts of general jurisdiction. The District Court has exclusive jurisdiction on felony cases, cases involving title to land, and election contest cases. It shares jurisdiction with the county courts, and in some cases, justice of the peace courts, for civil cases. Its lowest limit for hearing a case is a mere $200 in controversy, while JP courts can hear cases up to $10,000. Family law jurisdiction varies depending on the existence of a county court at law. In some counties, the district courts share jurisdiction over divorces, child custody, and support matters, adoptions, and child welfare cases with the county courts at law. Also, probate jurisdiction dealing with the adult protection, guardianship, and execution of wills varies depending on the existence of a statutory probate court in the county. In some larger counties, such as Harris County, the district courts are specialized, some hearing family matters, others hearing criminal cases, and a third set hearing non-family civil cases. In more rural areas, as many as 5 counties share a district court. Urban counties, on the other hand, have multiple district courts which in some cases specialize in civil, criminal, family law, or juvenile matters. One of the most unusual features of Texas trial courts, including district courts, is the tradition of having only one judge per trial court. Instead of adding more departments to existing courts in response to population growth, Texas adds more courts. The result is that a typical Texas urban courthouse is home to many single-judge trial courts, each of which is legally organized as a separate court with its own unique name and number. This contrasts sharply with the prevailing tradition in the federal judiciary and the courts of virtually all U.S. states, in which a trial court can have multiple judges sitting in separate departments, and all of which have authority to act in the name of the same trial court. While Texas law provides for certain specific circumstances in which a judge of one trial court can act for an absent judge of another trial court in the same jurisdiction, it is not as flexible as simply treating all trial judges as members of the same court, and in turn occasionally results in another basis for appeal. This tradition dates back to the hurried enactment of the Constitution of the Republic of Texas in 1836 by the newborn republic. Section 2 of Article 4 provides for not less than 3, no more than 8 judicial districts, and that a judge would be appointed for each district. Similar clauses implying one judge per court appeared in all subsequent constitutions. For example, Section 7 of Article 5 of the 1876 state constitution provides for 26 judicial districts, and that a judge would be elected for each district. The issue was finally remedied by a constitutional amendment in 1985, but the tradition of one judge per trial court was by then thoroughly entrenched. Some counties, however, have established a centralized docket system. In that system, cases are still assigned to a particular court and a particular judge presiding over that court, but motions and trials are assigned to judges on the day of the docket call based on workload considerations and availability. This facilitates more effective use of judicial resources, both judges and staff, but it makes the process less predictable for attorneys. Additionally, rulings in the same case are likely to be made by different judges as the case progresses through the pretrial stages, and hearing judges will be less familiar with the cases that they encounter for the first time at the time of the hearing. In counties that do use this type of system, attorneys know which judge will hear their motion and try the case, except when a visiting judge is assigned to sit for an absent presiding judge, which allows experienced attorneys in law firms to assess likely case outcomes and thus facilitate settlement. In complex cases with multiple hearings, the judge will become familiar with the case and the attorneys litigating it. On the other hand, a local court system in which the case stays with the same judge creates incentives for forum shopping. To counteract it, local rules typically require random assignment of cases when they are first filed and transfer of refiled cases after non-suit to the court to which the prior case was randomly assigned. The same applies to severance and other related cases. In another unique twist, the Constitution grants the legislature the authority to determine which court handles probate matters. Thus, In 10 of the 15 largest counties, specifically the counties of Bexar, Collin, Dallas, Denton, El Paso, Galveston, Harris, Hidalgo, Tarrant, and Travis, the legislature has established one or more statutory probate courts. These specialized courts handle matters of wills and probate, guardianship, trust, and mental health. In some counties, the statutory probate courts also hear condemnation cases. There are no judicial monetary limits on the amounts of lawsuits that a statutory probate court may hear. As such, their jurisdiction at times overlaps that of the district court. Not to be confused with county courts at law, which are created by statute, there is a county court for each of the 254 counties in Texas. The Texas Constitution states that there shall be established in each county of the state a county court. Section 15 through 17 of Article 5, as well as chapters 25 and 26 of the Texas Government Code, outline the duties of these courts and their officers. The county court has exclusive jurisdiction over Class A and Class B misdemeanors. Those offenses can involve jail time. Concurrent jurisdiction over civil cases where the amount of controversy is moderately sized, and appellate jurisdiction over JP and municipal court cases. For municipal court cases, this may involve a trial de novo, if the lower court is not a court of record. County court judges are not required to be licensed attorneys. Due to this, defendants in counties which only have the traditional constitutional county court may ask to have their cases transferred to that county's district court for trial if the district judge consents. However, defendants in counties with the county court at law structure do not have this option, as the county court at law judges are required to have law degrees. Since the county judge is also responsible for presiding over the Commissioner's Court, the main executive and legislative body of the county, in 94 counties, the Texas legislature has established county courts at law to relieve the county judge of judicial duties. In most counties with courts at law, the civil and criminal jurisdiction of the constitutional county court has been transferred to the county courts at law, leaving only administrative duties, Commissioner's Court. Unlike the county judge, judges of the county courts of law are required to be attorneys. The county courts at law may hear both civil and criminal matters, or hear them separately, depending on how the legislature has structured them. Dallas, Denton, El Paso, Harris, and Tarrant counties have county criminal courts or county criminal courts at law that hear only criminal cases. Statutory county courts at law, not to be confused with constitutional county courts, generally have broader jurisdiction than constitutional county courts. Statutory county courts can generally entertain lawsuits in which the amount of controversy is over $500 but not over $200,000. However, unlike constitutional county courts, the jurisdiction of statutory county courts can vary from county to county. For example, in Dallas County, statutory county courts have jurisdiction near as broad as that of district courts. In Harris County, the general jurisdictional cap is $200,000, but these courts also have exclusive jurisdiction of eminent domain proceedings regardless of the amount in controversy. In Travis County, the amount in controversy for matters the statutory court can entertain ranges from $500 to $250,000. There is no clear policy reason for the varying jurisdictions of the statutory county courts. Municipal courts in Texas come into contact with more defendants than all the other Texas courts combined. The subject matter of municipal courts relates to crimes relating to public safety and quality of life issues. In recent years, municipal courts and justice court in Texas have become the primary venue for acts of misconduct committed by children. Within the city limits, these courts have shared jurisdiction with the JP courts on Class C misdemeanor cases and have exclusive jurisdiction on cases involving city ordinances. Municipal courts have limited civil jurisdiction over public matters relating to public safety, for example, dangerous dog determinations and city quality of life ordinance issues. Confusion surrounding a municipal court civil jurisdiction is complicated that if a municipal court is a court of record, the legislature has authorized municipalities to adopt ordinances that give municipal courts concurrent jurisdiction over substandard building cases with county and/or district courts. The matter of civil jurisdiction has been further confused by the advent of civil penalties for conduct that can be prosecuted as a Class C misdemeanor, for instance, certain parking violations and red light camera violations. As a general rule, the municipal courts are not courts of record, meaning no court reporter records or transcribes the proceedings, and thus an appeal to the county level would require a whole new trial, also called a trial de novo. This proved to be a loophole for some defendants in traffic cases who bet on the officer not being able to attend, and thus having the case dismissed. Furthermore, the de novo trials crowded the dockets of the already busy county courts at law. Many major cities, such as those in Austin, El Paso, Houston, Dallas, and San Antonio, have chosen to convert their municipal courts to courts of record. This also requires voter approval to close this loophole. Municipal court cases generally have their appeals heard at the county court level, but cannot be appealed beyond that level unless the fine is more than $100 or a constitutional matter is asserted. The lowest court level in Texas is the Justice of the Peace Court, also called Justice Court or JP Court. Each county has at least one JP Court. Article 5, Section 19 of the Texas Constitution sets forth the minimum jurisdiction of the JP Court. Original jurisdiction in criminal matters of misdemeanor cases punishable by fine only, called Class C misdemeanor cases under the Texas Penal Code. Exclusive jurisdiction in civil matters where the amount of controversy is $200 or less, and such other jurisdiction as may be provided by law under this provision. The legislature has raised the top limit on civil matters to $10,000 and assigned the JP courts, among others, the right to hear cases involving eviction as well as cases involving foreclosure and liens against personal property, where the amount falls within the JP court's jurisdiction. In addition, marriage licenses are obtained through JP offices, and JPs are also legally permitted to perform marriage ceremonies. JP cases are appealed to the county court level where the case results in a trial de novo. While the case is retried on appeal, the jurisdictional limits of the JP court, rather than those of the court of record, usually a county court at law, apply. Appeals from JP Court also differ from appeals to the Courts of Appeals in that they require the This makes such appeals more onerous to losing defendants than appeals from county courts to the Court of Appeals unless the defendant qualifies to proceed in forma pauperis without financial resources. In criminal cases, cases beginning in justice court cannot be appealed beyond the county court unless the fine is more than $100 or a constitutional matter is asserted. Under Section 18, the number of JPs and associated constables each county has as many constables as JPs is dependent on the size of the county. Constables are elected officials who serve 4-year terms. A constable in Texas serves as a licensed peace officer and performs various law enforcement functions, including issuing traffic citations, serving warrants and civil papers such as subpoenas and temporary restraining orders on behalf of the Justice of the Peace Court to which they are elected.